Hello, everybody. Thank you for joining us for our lawsuits update webinar. This evening, we are joined by John Tobin, Natalie LaFlemme, and Michael Jowdy, who have worked on the Rand case, and Andy Valinsky, of course. Sorry, I don't have everyone right in a row on my screen. And then we have Elizabeth Ewing, who has worked on the Conval case. We're going to give folks just a minute or two to join. And as you're hopping on, if you're interested in quickly introducing yourself in the chat, we would love to know kind of where folks are joining from in the state, and if we have any elected officials with us, if you would like to identify yourself, that would be great. So I'm going to quickly just go through the format for tonight. We will be taking questions in the chat throughout the meeting. So as our panelists are going through their portions of the agenda, if you have questions that you'd like to ask, just pop them in the chat, and then my colleague Carly and I will take them and put them in a document to read to them at the end of the webinar. This is being recorded, so if there's, anything that you feel like you need to hear a second time, we'll be sending this recording out following the webinar this evening. And since we've got a lot to cover this evening, I'm going to go ahead and turn it over to our attorneys to get started.
Great, thanks, Casey. So as Casey said, we are the attorneys for two different cases. John, Andy, and Michael and I are working on Rand, which is split into two parts. There's one piece has already been up to the New Hampshire Supreme Court on appeal, and one piece had a trial in October that we're waiting for. I'm going to talk about the appeal piece briefly. In our case, our clients are all taxpayers. They are from Plymouth, Pennacook, Concord, Hopkinton, Newport, which is a little different than the Conval case that Elizabeth's going to talk about later, which are school districts. So in our case, Andy and John will talk about the trial portion, which deals with adequacy and overall funding. We were able to peel off a few issues involving SWEPT, which is the statewide education property tax, to isolate those, to have the trial court decide on summary judgment, which just means the facts aren't in dispute and you can just decide the issue on the law and not have to have a whole trial. So we did that, and then that was appealed by the state. We won, obviously. And then that was appealed by the state to the New Hampshire Supreme Court, and we had the argument in November. So the two issues are some communities keep the excess SWEPT. I'll explain that in a second. And the second issue is that the SWEPT is not collected in unincorporated parts of the state. So SWEPT, if you're not familiar, statewide education property tax, it is the tax that is ostensibly applied statewide at the same rate to raise money for the amount of adequacy that the state pays for schools. The way the state administers it is very localized. So the local municipalities assess and collect this tax. And it used to be, it would raise certain funds, and the extra that paid for more than adequacy in your community would go to the state to be used statewide. Currently, the state now permits certain communities to collect if there's any excess and not send it to the state. And what I mean by excess is if you apply the same tax rate to all the different places in the state, there's different property values. Some places have much more property wealth than others. So if you're applying the same rates to the places with greater property wealth, you raise a lot more funds than you do in property poor districts, which is where all of our plaintiffs are from. So that's what we mean by excess. It's raised by the SWEPT, but it's more than is needed in that municipality, community to fund adequate education in their schools. So that's the first part. The second part is unincorporated parts of the state. The DRA, the Department of Revenue Administration, still sets a SWEPT rate. It issues warrants for all of these locations for the SWEPT tax, but the state doesn't actually collect it. Again, because it's administrated so locally, there aren't local districts in those places. So the money would not go to fund the local schools because there aren't any. So the state tax is just simply not collected by the state, even though this is property in the state that should be subject to the same taxation as everyone else. So both of these issues make the SWEPT unconstitutional, because even though on its face, everyone's paying the same rate, because some places are keeping the excess or some places actually aren't having it collected, they're effectively paying a lower tax rate, which means it's ununiform and against the New Hampshire Constitution. Just briefly, what the state's arguments in defense of this is. Creatively, the state has argued, and there's also some interveners in our cases, which are a handful of communities that are the places that have the excess SWEPT that they now keep. And they argue that this isn't a taxation issue at all, it's a spending decision. Basically, the state is permitted to spend more money in some places than others. So by not collecting this SWEPT, the state is essentially saying, we are choosing to spend more money in these property wealthy communities on their education. I'll pause for dramatic effect for a second. Second, the argument for the unincorporated places is they're not municipalities, and the statute uses the word municipalities. Never mind that other parts of the statute, the DRA definitions, other case law uses it interchangeably to mean unincorporated places as well. The state says it shouldn't apply there. And yes, the DRA has been doing that for time immemorial, but they're wrong, and we just never mentioned it before. So those are their two arguments. I think you know how I feel about the arguments, but anyway, we are waiting on a decision. We hope it will come soon, but you know, there's really no way to tell when we will get one, but that is the SWEPT appeal. I'll turn it over to John next to talk about our trial.
Good evening, everybody. It's very glad that you're all here to learn more about these cases. So the trial in Rand took place before Judge Ruoff, the same judge that heard the trial in Conval. That took place last fall. It was 2 weeks, and the two main things that we were trying to accomplish in the trial, one was to show that this level of state funding for base adequacy, as in the Conval case, and also the differentiated aid, and most particularly special ed, that those levels are too low. They're way too low. And as in Conval, the state presented no evidence to support those current levels. They just tried to challenge, nitpicking in certain ways, the support that we provided for the fact that that these numbers are way too low. We had two very experienced superintendents go through their budgets in detail and just explain how little the state's money actually pays for. And we put, as I mentioned, we put a lot of emphasis in this trial on special ed. Special ed is about a quarter of all spending on public education in this state. It's $900 million or so. And the state pays a very small fraction of that, so that the burden falls on local property taxpayers. So our case is for taxpayers, as Natalie mentioned. So showing that the levels of funding are too low, the next step is to point out the fact that because they are low, local property taxpayers make up the difference. The state is not paying the full cost of adequacy. It's shifted to local taxpayers, and those taxpayers pay for that at very different rates because of the great variations in property wealth in their towns. The result is that taxpayers are paying for adequacy, the state's duty, at very different rates. And that violates one of the core precepts of our Constitution, that any state tax is supposed to be uniform in rate around the state. And a tax to pay for adequacy, which is a state duty, is a state tax. So, as I mentioned, the state didn't really try to contest the amounts of, try to support their current fundamentals for adequacy or differentiated aid. After that trial, we submitted briefs, and we're now waiting for Judge Ruoff to make a decision. And now I want to turn this over to Michael Jowdy and then Andy. Michael Jowdy, the volunteer lawyer from New York, as part of a wonderful cadre of pro bono lawyers that we have, who spent months on this case for free, pro bono. And I would snidely contrast that with the state, who has hired a very expensive law firm in both Cottonville and our case, $400 an hour or more to try to defeat taxpayer claims and school district claims. So Michael, let me turn it over to you.
Great. Thank you for that introduction, John. Hi, nice to meet you all. My name is Mike, and I was a trial attorney at the at the Rand case that John was just talking about. And I wanted to highlight a few key pieces of evidence that we demonstrated that I think really tell the story of the gap between the funding the state provides as adequacy and how much districts need to spend to provide the basic necessities for students. So notably, I think the first most important fact was that no district in New Hampshire is spending nearly as little as the state is providing them for adequacy. In fact, the lowest spending district is spending about 3.5 times that amount. So it's roughly $13,000 versus the $4,000 in change that the state provides as adequacy. And importantly, we had many great witnesses who have devoted their life to education, one of whom I believe is on the call. I saw her now, Dr. Cascadin, who testified from their experience about the struggles that districts face while trying to meet the budgetary concerns provided with such few resources from adequacy. One of those witnesses was Dr. John Freeman, who was a longtime superintendent at the Pittsfield School District. If you're not familiar with the Pittsfield School District, it's one of the lower spending school districts in the state. And by way of sort of comparison, their average teacher salary is actually the third lowest statewide. So Dr. Freeman runs a very cost-efficient budget for his school district. And at trial, he testified about an experiment he ran where he took his school budget, which was about $10.2 million, and tried to reduce it to the $2.7 million he received for adequacy. And the results were that he couldn't even open the school doors because with the $2.7 million, he could only provide enough teachers to teach a handful of subject areas required by adequacy, which were the core, as he called them, math, science, social studies, and English, and provide a subset of special education teachers, which meant that with just the adequacy funding, he didn't have enough money to provide facilities, nurses, technology, classroom materials, a physical education program, arts program, a music program, guidance counseling services, any principal or superintendent services. He couldn't even provide transportation for students who had no other transportation to get to school. So in essence, he was running a hollow shell of a district in this hypothetical scenario, just using the state's funding. Importantly, he decided that, well, what if I count the other sources of funding beyond adequacy? And that includes both state and federal funding that is not guaranteed year to year, that can vary, but is sometimes provided to the school districts. And he concluded that if he added all that money, he would double his budget to $5.2 million. But even with that, he still couldn't provide most of the basic services, which were nurses, technology, and all the stuff we talked about. Essentially, that additional money allowed him to round out class sizes, to keep class sizes below 30 students, and provide some additional resources for special education students and minimal administrative services. And so when you compare what Dr. Freeman's budget was, a lot of it were things that were basic necessities for an adequate education, and yet his budget was still double what he was receiving for adequacy. And even then, he couldn't meet the basic tenets of bringing kids to school, making sure they were safe, providing clean facilities, providing healthcare services, and really meeting some basic educational standards that we all accept today. So in contrast to the state that provided no evidence justifying their budget, we had Dr. Freeman who testified that it was not even remotely close. And I'll turn it over to Andy if he wants to add in anything to that.
I would just add a quick point about what was not in our case. Drew Klein, the chairman of the State Board of Education, didn't show up, nor did Frank Edelblut. So neither of them defended the state's low level of contribution, which is particularly interesting since Chairman Klein just issued a report about the spending per pupil in our state, claiming, using some fairly questionable economics, that spending is not producing the results that we deserve, and questioning school budgets in our state. The time to have come and said something meaningful would have been in our trial. He didn't show up at Elizabeth's trial either. Frank Edelblue was there, and she can talk about his performance and what he knew or didn't know. But it's particularly telling that these folks will take pot shots at educators and administrators and school boards from the safety of their think tanks. But when the rubber meets the road in a trial, they don't show up. So I'll leave it there. And
We're
I
gonna
guess,
over
go
to
ahead.
Do you
Yep.
want to?
Elizabeth now.
Perfect.
Hi, everyone. I'm so glad to be here, and I apologize in advance for my voice. I'm dealing with a little bit of a cold here. As they've mentioned, the other attorneys on this call have mentioned, I represent 18 school districts in the Conval lawsuit, which is currently pending up at the Supreme Court. We had oral arguments on December 10th. And just briefly, the history of that case, which it blows my mind, but is now 6 years long. We filed that lawsuit in 2019. And we brought that lawsuit focusing on only one aspect of the state's funding. So the way that the state calculates what they call the cost of an adequate education, and the air quotes are doing a lot of work there, is by adding what they call base adequacy, which is what it costs to educate the least costly to educate child, and then a number of differential categories, including special education, students who qualify for free and reduced price lunch, and some other categories. So we were focusing just on that first element, which was the least costly to educate child. Because if the state was underfunding that amount, then it was underfunding education for everyone, everywhere. So that was the main focus of the Conval case. And in 2019, Judge Ruoff ruled for the school districts on the pleadings, did not require a trial, and held that the state was underfunding inadequate education. The state appealed that, and the Supreme Court of New Hampshire overturned Judge Ruoff's decision, saying that he needed to permit the state to conduct factual discovery and to have a trial on the factual issue of what it costs to educate a child in the state of New Hampshire. Beginning in April of 2023, we had a 3-week long trial during which we had, I want to say, more than 20 expert witnesses testifying, many of them experts from the local districts, the superintendents and the business administrators that are actually on the ground every day figuring out what it costs to educate kids in the state. Interestingly, the state did not provide any evidence in support of the amount that they provide, which at the time was about $4,100 per student. It climbs just a little bit every year. And Judge Ruoff found that the state is underfunding an adequate education, that base adequacy amount, by more than $3,000 for every student in New Hampshire, which I don't do a lot of math. I'm going to rely on Judge Ruoff's math. That is $537 million and some change under what the state should be funding. So again, the state did not put forth any evidence that you could educate any child anywhere for $4,100 per student, and instead complained that things like heating in the building are not part of an adequate education. Those are extra. So at this point, we are fully briefed. There were oral arguments on December 10th, and we're waiting for a decision. We did get an order appointing 2 retired Superior Court justices to sit on this case at the Supreme Court because there were only 3 justices available to sit. So we will have a full five justice panel. Oh, and I should follow up on what Andy mentioned. Frank Edelblut did turn up at the Conval trial, and he said he was not responsible for knowing how much an adequate education costs, and he did not know what it took to educate children in New Hampshire.
Great. Thank you, Elizabeth. We're going to hear from Natalie really quickly before we move to our next piece.
Yeah, I wanted to add one more thing on the legal case end. Just something Liz had said about her case has been going on for 6 years. And if you recognize Andy and John, it's because they've been doing this for 35 years. They were both on the OG Claremont lawsuits in the early 90s. And here they are, God bless them. But as important as all of this is, and as much work as everyone on this call has put into these cases, we're really not reinventing the wheel here. The New Hampshire Supreme Court basically decided these cases decades ago. And here we are again. And even in our case, the swept appeal that I talked about, by our count, this is the 4th time that the New Hampshire Supreme Court will be asked to answer the very specific question of, can you keep excess swept, or is that unconstitutional? Spoiler alert, it's unconstitutional. So I just wanted to make sure that that's clear, that the state has been dodging this for almost my entire lifetime, frankly. But anyway, but there is hope because there's legislation, right, Casey? That's my segue to you all.
Thank you very much, Natalie. All right, with that, I'm going to pass it over to Andy, and he is going to talk a little bit about what the legislative implications of all of this, and specifically 2 pieces of legislation that will be heard before House Judiciary next week. So Andy, it's all you.
Okay, thanks everyone. I think it's fair to say that in a well-functioning society, public policy is not made by the courts. Courts identify and establish constitutional minima, but lawmakers make the law. Lawmakers and governors in our state executive councilors make public policy. And they all understand that they can do more and do different things than a court can. They can make public policy much more effective. But it takes lawmakers willing to do that. So as everyone knows, let me give you one example. New Hampshire has an aging population. Our population of school children goes down each and every year. Courts can't say that New Hampshire has respect for educators and for schools. Legislators can do that. Courts can't, other than setting the minimum, they can't make taxes fair. They can't say it was a bad idea to repeal the interest and dividends tax and blow a hole in our budget that Governor Ayotte now has to deal with. That's not their job. Courts can't say that we should spend more money on community college and public university and create a solid connection between K-12 and community college and public university. They can't address pre-K and daycare. The New Hampshire Fiscal Policy Institute just released a report saying that we lose more than $50 million in revenue in our state for lack of childcare. Those are legislative public policy decisions that our legislature can and should deal with. They should not rely on the courts. But we're in a state, we're in a circumstance where the legislature tends not to act absent court prodding. And that's why we're going to court. And either the court's going to say, legislature, you need to fix this, or the folks on this webinar and some others are going to show the hypocrisy of our current system. It isn't working. It is not fair. And we're going to keep going to court to say that. So we hope the legislature will do its job. There are two, I guess they're called bills. One is HR 7, and the other is HCR, House Continuing Resolution 11. So HR 7 is a bill that asks permission to investigate Judge Ruoff for having the temerity to consider the facts and apply the law. I want to be clear on who's sponsoring that. Representatives Belcher, Bernardi, and Weiler are the sponsors of that bill. It's not an impeachment bill because they don't have any grounds to impeach, but it's a bill to investigate Judge Ruoff because of his ruling in Liz's case. That's scheduled for a hearing, and my friends Carly and Casey will talk about how to get your position known at a legislative hearing, but that hearing is on March 5th in the Legislative Office Building, rooms 206 to 208, and I think it's at 1 o'clock. Representative Weiler, by the way, chairs finance. He's also the representative who was censured a couple of years back for circulating a scientific report showing that microchips were being installed with vaccines in New Hampshire and across America. The second bill is the HCR, the House Continuing Resolution. And that resolution is designed to it's designed to ask the legislature to agree that they don't have to follow court orders, is the bottom line. And that respect for the law, respect for rule of law has no place in New Hampshire society. Think about that for a second. If times were different, the folks who are sponsoring this bill, this House resolution, I'll tell you who they are in a moment, would be laughed out of the legislature. The Republicans and Democrats would shun them. They wouldn't be allowed within miles of the civics classes that they require public school students to take. This is as basic a bedrock of our constitutional system. The court interprets the law, the legislature follows the court's interpretations. With respect to school funding, this House Continuing Resolution wants an excuse not to abide by that bedrock principle. So if you're ready, here are the representatives who have sponsored HCR 11. By the way, it's being heard at the same time as HR 7. That's March 5th, 1 o'clock, rooms 20608 in the Legislative Office Building. The sponsors are Gregory Hill of Northfield, Jim Kofalt of Wilton, Thomas Walsh of Hooksett, Keith Ammon of New Boston, Carol McGuire of Epsom, Glenn Cordelli of Tuftonboro, Joe Sweeney of Salem, Juliet Harvey Bolia of Tilton, and Leonard Turcott of Barrington. I'll end there.
Thank you, Andy. Yes, so like Andy said, so before we move into Q&A, I'm going to talk just a little bit about those two pieces of legislation, and for folks on this call who might be interested in signing in opposition of those two bills or submitting online testimony. The way to do that is to go to the General Court website, and I'll send these instructions around in our follow-up email as well. on the general court website, you go up to committees, and then online testimony submission sign in is where you can sign in support or opposition of legislation there. And what Carly is about to put in the chat, it looks like she just did, is an advocacy tool that our organization, the New Hampshire School Funding Fairness Project, has created that with one click will send your testimony to all of the members of the House Judiciary Committee. And that tool has a really solid explanation of those two pieces of legislation if you'd like to refer back to them to get a refresh on what Andy just explained. And it also has a message that's pre-written out that you're able to edit and then send off. So it gives you a nice, easy starting point. And that is all I have in terms of the two pieces of legislation. So now we're going to transition over into Q&A. I have a couple questions to get started with, and I'll just remind folks that if you have any questions as we continue to put them in the chat, and we will read them off. I'm going to read these questions, and then I will Andy, Michael, Elizabeth, Natalie, and John, I'll just let you folks decide who is most equipped to answer. But one of the first questions that we got in the chat is, who is responsible for determining the cost of an adequate education in New Hampshire?
So I'll hop in on this. I think the question was, what do the RSAs say about it? And the RSAs don't say anything about it. The Supreme Court has said that the legislature is responsible for determining the cost of an adequate education in the first instance. That doesn't mean that the legislature can say it only costs $2 and it is then impervious from review. It just means that in the first instance, the legislature has the responsibility to determine the actual cost of an adequate education, which is then subject to review by the court.
Right. Thank you, Elizabeth. This is a little more, a bit more vague, but why should we be optimistic about the future? You know, kind of regardless of what the court decisions are here. Maybe if you folks could talk a little bit about just kind of what your predictions are and what's keeping you going in this fight, I think that would be great.
Well, I'll jump in and say, I think what keeps me going is I believe in the Constitution. The Constitution is a venerable document, and it has some core principles. One of them is we have a responsibility to educate our kids. Another one is we have a responsibility to tax ourselves fairly and not in a way that benefits the wealthy few. And those are solid principles. Those are principles most people agree with. I've noticed in the last couple of years at Croydon and at Kearsarge and at Epsom recently, when people really understand that the future of their schools is in jeopardy, they turn out en masse to protect their schools. So I think there is great public support in New Hampshire for public schools. And I am optimistic that the court recognizes the constitutional principles are clear and the court's own credibility is at stake. And so I'm optimistic that they will do their job and enforce the Constitution.
So John's our resident optimist, obviously, but I'll try to add on too. As far as from a legal standpoint, what might be different, and this is really Elizabeth's case, but Conval, when it went up on appeal the first time, the Supreme Court did something a little different where they specifically asked Judge Ruoff to identify some kind of number. And that is different from the previous cases where the court would just say, it's not enough, which is true, but this was kind of the first time that the trial court produced a number. So we'll see what the Supreme Court does with that on appeal. You know, we're still waiting, but I do think that's one way to look at it, as a little different from all these past cases that we say we keep relitigating over and over again. And to John's kind of point too, I do think there's, at least seems to me, the last few years compared to, I don't know, 10 years ago, I think there's more awareness on the part of people of kind of how this works and why it matters and how it affects them. So I think that is also a positive thing. But, and this is why it's important what Casey and Carly were talking about, and they're going to email around. It's really important that the public lets their voice be heard on this. We lawyers can't do it alone in the courtroom, as has been shown. So we really need that public pressure on the legislature to get things done. So definitely, if you've got more questions about that, please ask. But we could really use your help because we are doing what we can, the good fight on the case law side, but we could really use some help on the legislature side.
Great.
Can I?
Oh.
I would second everything that John and Natalie just said. But for me, it's really not a matter of optimism. It's really a question of what other choice do we have? I went to a school much like Claremont. I'm the only one in my family to go to college. I know where my friends ended up. I know where my siblings ended up. Schools make a difference. And, I know what John and I learned in the Claremont trial. I'll say there's a photo that still haunts me. It's of a bathroom, but the bathroom was being used to teach children who qualified for special ed and to provide them one-on-one services. So the most picked on kid in the school was getting pulled out of his regular classroom to get special help in a bathroom in New Hampshire. That's unacceptable. And so, in part, we need to be optimistic. In part, you just can't let that happen.
Thank you, Andy. So before we move on to the next couple of questions, I kind of just want to echo what Natalie and Andy are saying about getting involved by submitting testimony or signing in online to support or oppose these pieces of legislation as they come before committees this legislative session. And so I just wanted to give an example of a bill that was before committee a week or two ago. It was House Bill 283, and that was a piece of legislation that really gutted the what's entailed in an adequate education. And there were over 30,000 Granite Staters that represented every single city and town in the state that signed in against that bill online. Only 71 people supported that bill, and it stopped it in its tracks. So it really does make a difference when folks go online and use these tools to get involved. So I would just say again, if this is resonating with folks who are on this call, we would really encourage you to use the tool that Carly pasted in the chat. If you want to bump that again, Carly. So I just wanted to say that quickly before we move on. The next question that I've got is, even if the courts rule in favor of your arguments, who or what will make the legislature follow the court orders this time if they have yet to do so? Oh, John, you're muted.
That's a great question. And I think that what will eventually make the legislature do what they're supposed to do are the people of New Hampshire, and in concert with what the court says. And I guess I would go back to the property tax issue. It amazes me that there are people who don't care about our public schools, but everybody cares about their property taxes. And everybody knows that the property tax burden in New Hampshire is among the highest in the country. So I just urge people, whenever you run into a live legislator, ask him or her what they're going to do about your property taxes, because the property tax burden is outrageous and unfair, and everybody knows it. And we just need to put pressure on those legislators to respond to that, and they know it. So it's too soon to say how we would move to actually enforce a favorable decision that we receive. We have options and choices, and there are ways that has happened in other states where there's been a little recalcitrance and slowness, and then in other states, the courts have found ways to nudge the legislature to finish the job. But ultimately, it's up to us as citizens to really put the heat on the legislature.
So I'll co-sign what John said, and then just 2 points off of that. First, I think what's helpful to keep in mind and to maybe explain to your friends and neighbors who are less on board with this issue is you're already paying for the school. So we're not talking, when we're saying the state should pay more, we're not saying you are going to be taxed more. We're saying it's going to be shifted to the state, which would likely be more equitable for most people and not such a burden on your local property taxes. So I like to make sure everyone understands that you're already paying for your schools. You're just doing it most likely at a grossly disproportionate rate on your local taxes. So that's point one. Point two about what will make the legislature act to what we've been saying, people pressuring them a little more. I think also as far as the courts, when Elizabeth's Conval case was up on appeal last time, John and I had actually done an amicus brief in that case as well. Our case wasn't a thing yet, where we, kind of pushed a little bit of like, come on court, do something. To John's point, like there are certain things you could do. And I think when and if we get the rest of our case to the Supreme Court on appeal, maybe we'll be feisty in our brief again. I don't know, hopefully. But I think, and maybe John or Andy had said this earlier too, at a certain point, the court needs to look at itself and its own credibility and what message does this want to send? If they know that there are people in New Hampshire legislature that are like, we don't have to follow the court. What do you as the New Hampshire Supreme Court, a branch of government, do with that? Do you kind of just shrug and like, let them ignore you? Or do you try to figure out a way to give your order a little more teeth so that they can't ignore you and that you're actually, still legitimate? So we'll see what the court does there, but I'm hopeful that they'll recognize kind of the threat that they are under if they don't stand their ground a little bit.
Thanks, Natalie. Can we talk a little bit about the what the possibility of reaching a unified definition of an adequate education between the legislative, judicial, and executive branches are? And just to follow that up, somebody in the chat made a good point that when Article 83 was initially drafted, it was grades 1 through 6 in schools. So if we could just clarify a little bit about what exactly we're talking about here when we're talking about an adequate education.
If I can, I'd like to tackle the first part of that. I think it's important to know that the state's obligation under Part 83 has actually 4 subparts. So the first part is to define an adequate education. The second part is to determine its cost. The third part is to fund that cost. And the fourth part is to ensure its delivery, the delivery of that education through accountability. The legislature has done the definition. I don't believe, although John, Natalie, correct me if I'm wrong, I don't believe that Rand is arguing that the definition is somehow defective. The question is that second obligation. Are they appropriately and accurately determining what the cost of providing that defined education is? And then the third part is, are they funding it through constitutional taxation? And so everybody sort of agrees on the definition. It's that determining the cost and funding the cost that are at issue at this point.
So I think I just want to hop on that to talk a little about the definition issue. I think what is difficult is that there's no uniform understanding between us or the executive, legislative, the court as to how you interpret the definition. So for example, the state says we've defined an adequate education. And when you ask them what it is, it says, well, there are 12 subject areas. And as long as you have a teacher who is teaching those 12 subject areas, that's all there is, right? But how could you have an adequate education if you don't have a classroom, if you don't have basic support services, if you don't have, health and wellness and physical education and all these things that are found in regulations that the state promulgates, but turns around and says, well, those aren't part of the definition of adequacy. They're just things the district has to fund of their own accord. And so I think there isn't right now an agreement on how you interpret the definition. And part of that problem is because the definition is so loosely worded. And when the state costed out inadequate education, they didn't explain how they got to their cost either. So there's nothing really to point to where we're all in agreement as to this is what you need to provide and how much it costs.
And who are we talking about when you say the state is to determine something? If we could just clarify that.
Sure. So I think that in this case, the state is being represented by their lawyers, the AG, who are speaking allegedly on behalf of the legislature that codified the RSA at the time. So they're advancing their interpretation as the legislature's interpretation.
Mhm. And then I did want to just plug that. So Andy mentioned a couple of things in the chat here, but I do want to highlight that Andy sends out a Substack once a week, every Wednesday, I believe it is. And a lot of the stuff that we're talking about here tonight is covered in that. I am trying to dig around for the link to subscribe to that, but Andy, you might be able to find it more easily than me. So if we don't get it in the chat here, we'll be sure to send that around in our follow-up email. So moving on here, I will just say that we have about 10 minutes left. So if anybody has last minute questions to put in, now would be the time to do that. That's a great question that just popped up in the chat. Who is paying for the state's lawyers in these cases?
You are.
Yeah, you are. We are.
And someone might need to remind me of the numbers, but the project had done a right to know request. I think it was just for the Conval case of how much has the state spent on even just outside counsel. As John mentioned, they have some attorneys from out of state that have come and helped them try the cases. And I think it was like $1 million just in outside. So that's not including the time and resources of the state attorneys, the attorney general that have put into that. So then you figure they had outside counsel in our case as well. So millions of dollars have gone into fighting to spend more equitably on schools. Can I just mention, I saw somewhere in the chat something about another question about messaging and such. So I did kind of want to say a few things of kind of the common refrains you'll hear is, well, local control, we don't want the state, whatever. And I would just kind of press back on local control doesn't necessarily mean everything has to be from local taxes. You can still have local control with a more fair funding system in the state. So I think if people push that, I would push back and just be like, what do you mean? Why wouldn't it still have local control? And then second, I think there's obviously this whole idea of, well, states are just schools are just overspending. And I think I would encourage people to really look at budgets and see there's not much discretionary spending in school budgets. There are so many requirements and regulations, both state and federal, that schools have to meet. So much of the budget too is staff is a huge section of it. What are you going to do? Like cut every teacher's pay in half? No. So I think a lot of that, there's much less wiggle room in schools' budgets than I think most people understand. So those are just kind of questions that you could keep in mind when you're pressing back about some people that might be arguing against some of these things.
And I do just want to emphasize quickly that the New Hampshire School Funding Fairness Project is a nonpartisan, nonprofit organization. So all of the attorneys that you see on this call, we are not formally affiliated with any of the lawsuits. Our organization aims only to educate folks, connect them with resources, and to support the lawsuit. So I just wanted to clarify that before we move on. Does anyone have any advice on how to effectively combat the groups of individuals that are showing up in district deliberation sessions with the intention of slashing budgets below the default or capping the cost per pupil? I can read that again if it would be helpful, just let me know.
I don't have any advice except, keep your drinking in check. If there's anything we can do to to help you with your mental health, let us know.
I mean, one thing, I mean, I just think it's been really neat when the people have showed up at school district meetings. In Croydon, they did a surprise on a snowy night, snowy morning with not much attendance. But then the the masses of people in Croydon responded and they packed the halls with people who cared about schools. And that happened a few weeks ago in Kearsarge and it happened in Epsom. And there are really a lot of good people who know how to organize in their community to bring people out. It's a great skill and there are people who care and it's something that can be done everywhere. And so, and I think it's amazing how much support there is, how much people wanted to come out. People were telling me about the Kearsarge meeting that people were parking on a mile away because so many people wanted to go. And so I think, New England community organizing, the barn raising thing for the 21st century, I think it can happen. Local people can make it happen and send a message.
And I think the key there is like to not get complacent. As great as what Croydon and Kearsarge was, it shouldn't have necessarily been necessary that there needed to be this like, oh no moment after, the town meeting, deliberative session, whatever happened. So, if there are these small little groups, I think the question was like infiltrating, which is a fair word. Maybe just make sure people know that ahead of time and also try to infiltrate so that we don't have these kind of panic, which again, they are great that people do turn out, but people could be turning out sooner to avoid the crisis situation that we've seen. And I think a lot of that is just people just don't realize it. I think people have just gotten comfortable with 20 people go to our town meeting and vote on the budget and always seems to work out. Well, sometimes it doesn't. So I think just making people aware that these are continual issues, every year you got to go and fight for the school budget.
Are the potential changes to the Federal Department of Education of concern relative to the current anticipated court decisions? Does anything that's going on in the federal level have any implications for what we're talking about here tonight?
So there was a case in 1973 decided by the US Supreme Court that said education is not a fundamental constitutional right. And because of that, all of the school funding litigation, like we've been talking about, is done based on state constitutions. So activity regarding the US Department of Education doesn't affect the legal parameters of this kind of litigation, but could be a huge problem for school funding in general. Schools like New Hampshire generally get 5 to 7% of their funding from the federal government. A lot of that is Title I, which is younger children living in poverty. And a lot of that is special ed funding. Those are very expensive areas to be paid for. And it would be difficult for New Hampshire and a lot of other states were that funding to go away. Supervision by the Office of Civil Rights is important. And for that to be used to threaten states, Maine Governor Janet Mills said it, we'll see you in court. And so it's important to try and protect the US Department of Education, even though it's not the basis for our lawsuits.
Great. All right. So that is about all the time that we have. Before we say goodbye, I have a couple of things to cover. So I just wanted to let folks know that as these things are happening in your towns and as these pieces of legislation are coming up in committee, our organization, the New Hampshire School Funding Fairness Project, is here to help support the work that's going on in your communities. So if anybody ever needs help, constructing talking points for testimony, if you want a statement to read at your town deliberative session and you need some help compiling data for that, or information to help feel more confident as you're doing that, please feel free to reach out to our organization. Sign up for our newsletter if you are not on it already. That is how we send out alerts that include that information on what pieces of legislation are coming up and how you can sign in support or opposition. And we will be, like I said, sending around this recording of the webinar once we hop off tonight. And if you think of any questions that you would have liked to ask the attorneys that you didn't get a chance to, or if something comes up in the next couple of hours as things are percolating, please feel free to reach out to me and I will get an answer back to you. My email is cneal@fairfundingnh.com. I will put that in the chat. And I just want to say thank you so much to the attorneys that have been here with us tonight. We're very grateful for the work that you're doing and lucky to have you. So thanks for making the time to be here and to provide this educational content for folks. Thanks, everyone.